Joined in our Pretoria studio by legal expert Dr. Llewellyn Curlewis. A very good evening to you, Dr. Curlewis. Can you just tell us, what is your reaction to Oscar Pistorius being released on correctional supervision tomorrow, a day short of spending a year behind bars?
Good evening. No, it's no surprise after all. If one takes cognizance of our Criminal Procedure Act and the requirements in terms of Section 276(1)(I) of our Criminal Procedure Act, it was actually envisaged that he will be released and converted into ordinary correctional supervision after 1/6 of his sentence have expired. And by this time, it's already been 10 months or longer, almost a year, basically. So nothing new. The unfortunate situation is that there is still a sword hanging over Oscar's head, in the sense that in 2 weeks' time, more or less, the Supreme Court of Appeal will have the final say with regard to Judge Kgosi Mampuru decision and ultimate sentence on the issue. And there's always the possibility that they can alter the decision, and in which event we are in for a second round. And we will have to look what happens and what the developments will entail in Bloemfontein.
Just talk us through very briefly that process of that appeal of his sentence and conviction. What's likely to take place?
Well, first of all, he will be released tomorrow, obviously. It's basically a conversion of correctional supervision, which entails that he will be under house detention. Obviously, there will be certain requirements to be met, prescribed programs and treatment programs that he must undergo. There will also be a monitoring phase, and basically there's a wide discretion open to the Commissioner of Correctional Services to decide exactly what this, let's call it an umbrella sentence, will entail. But in 2 weeks' time from now, the Supreme Court of Appeal must determine whether Judge Mampuru was wrong in convicting Oscar Pistorius only on a charge of culpable homicide. If they succeed, and that's from the perspective of the state, in convincing the SCA to then alter it and find him guilty of murder, then obviously, being a first offender, he might go into another imprisonment period for between 15 to 20 years being a first offender. Obviously, if there are compelling and substantial circumstances, a court can deviate from that prescribed minimum sentence. But if the SCA concurs with Judge Mampuru finding of and conviction of culpable homicide, then obviously that will be the end of it, unless for some reason some kind of constitutional issue comes into play, in which event we might even be in for another round in the Constitutional Court at a later stage somewhere next year.
So this matter is seemingly far from over. If the Supreme Court of Appeal does agree with Judge Mampur's finding and Oscar Pistorius is under correctional supervision, is he likely to spend that entire 4-year period under correctional supervision? At any time, can correctional services then shorten that sentence?
Now, what must happen is obviously he is eligible to sit out the total 4 years that is left, because ultimately he was sentenced to 5 years. So it will be highly unlikely that they will deduct or shorten that period, and ultimately one can safely assume that he will then sit out the remainder of the 4 years that is still left. The only intervention that is in the discretion of the Department of Correctional Services and ultimately with the Commissioner is obviously with regard to the programs that they can actually call upon him to alter at any given stage during this period of the remainder of the 4 years that is left.
What happens if he defaults on those conditions that you mentioned, not owning a firearm and continuing with his psychotherapy? Then what happens?
In terms of Section 73 of the Correctional Services Act 111 of 1998, the Commissioner can then, and the Parole Board for that matter, can then issue a warrant for his arrest, bring him back before the board, reconsider the programs and the whole issue regarding his correctional supervision, and they might or might not then alter the various conditions, and they might even be inclined to then put more stringent matters and programs into place, or they might even ask that he be remitted back to prison. So it's a blanco carte blanche that's basically in the discretion of the Parole and Correctional Services Board, as well as the Commissioner of Correctional Services.
Dr. Curlewis, I want to take you back in time a little bit to ask you, what did you make of the timing of Justice Minister Michael Masuta's intervention in Oscar Pistorius' parole process?
Yeah, well, that was a point of much contention and obviously debate between members of the legal fraternity as well as members of the public. I have actually perused in detail the legislation applicable, and I must conclude that Justice Minister was within the scope and of the legislation. So there was nothing extraordinary in his determination to refer the matter to, let's call it then, the review board. But that is in comparison to the old system and the previous Correctional Supervision Act of 1959. So well within the scope of his legislation he acted. But obviously, one tends to ask the question, why only wait for a day or two prior to him being released on the previous occasion? That was a bit of a gamble, and one would have asked the question, why wait up to such a late stage before you make that call? But he did conclude, and obviously the review board also concluded, that the initial parole board acted prematurely in their decision, and he was quite correct in his determination. So I can't find any wrongdoing in his call on that one.
Do you think perhaps that Oscar Pistorius is receiving preferential treatment while thousands of other prisoners wait for lengthy periods of time before receiving parole?
Well, first of all, we must distinguish between parole and correctional supervision. Although it's basically the same board that has to determine these two issues, one is only eligible for parole if you receive direct imprisonment. And remember, in this instance, Oscar Pistorius actually received correctional supervision under a specific section of the Criminal Procedure Act. This is basically a conversion into ordinary correctional supervision. So make no mistake, this is not a situation of ordinary parole where you can only be eligible after serving at least, let's say, a half of your sentence. In terms of the Criminal Procedure Act, the parole board was well within the legislation to determine whether he can be converted into ordinary correctional supervision after the expiry of 1/6 of the sentence. And more than 1/6 have now expired. So once again, nothing untoward in the decision that was ultimately handed down.
Very briefly, Dr. Curlewis, do you think there's any lessons the legal fraternity can take from this Oscar Pistorius case?
Well, obviously, I can safely assume that the President will be set for future similar cases. The mere fact that we are in the Supreme Court of Appeal in 2 weeks' time in itself implies that this matter will be reported and will form the subject of future academic exercises for future law students. And obviously, there's also this question relating to the interpretation of the so-called dolus eventualis intention rule that everybody was speculating about over the last couple of months. And that per se is one of the major issues that must be determined by the Supreme Court of Appeal. And depending on their interpretation, they will set the tone for future interpretations in terms of our precedent system that's applicable in law, which means that every court out there, criminal courts out there, ranging from the lowest courts up to the high courts all over the country, all of them are bound by the decisions that was handed down by the Supreme Court of Appeal, our highest court in these matters.
Legal expert Dr. Llewellyn Curlewis, thank you very much for your time and insight, coming to us live from our Pretoria studios, unpacking that imminent release of Oscar Pistorius. He will be released on correctional supervision tomorrow.